start my speech from this place, sir.
Okay.
Thank you, sir. First of all, I would like to
Granted permission.
thank you for giving me an opportunity to start the debate on this Companies Bill 2011, sir. And I would also like to thank our leaders, Srimati Sushma Swarajji and Shri Shivkumar Chanabasappa for giving me this opportunity to start the debate on 2011 Companies Bill. And before starting the debate, sir, I would also like to congratulate our young and dynamic friend, Mr. Sachin Pilotji, for becoming the Corporate Affairs Minister. And I also wish him all the success in handling his ministry, sir. Now, coming to the subject of Companies Bill 2011, sir. Companies Bill was enacted in 1956, sir. And in the last 55 years, it has been amended 25 times. And at that time, as Honorable Minister was referring, there were around 30,000 companies. And right now, we have more than 8.5 lakh companies, which were 30,000 in 1956. Now there are about 8.5 lakh companies functioning as on this date, sir. Many changes have taken place in India post 1991. And as far as I want to, you all appreciate that, you all know, I want to refresh your memory by saying that when the Companies Bill was started in 1956, the economy in this country was a stint of communism in that nature, sir. And in the next 2 decades, it had a stint of socialistic approach. And now, post-1991, we all know after the liberalization, it is more of a market economy and it has got a stint of a capitalistic approach. We all know that, sir. But what I am trying to say here is, sir, post-liberalization, Indian economy has seen substantial changes and expansion and growth. It has happened in the last 2 decades, sir. So change in regulatory structure for corporate sector is very much necessary to address issues relating regulatory harmony, good corporate governance, and the good corporate practices and technological improvements, sir. Sir, the Companies Bill was drafted in 2009, seems to have become Companies Bill 2011. Is it just a chronology or pathology? I think it is, the truth lies in between, sir. With a number of big national scams inexorably winding its ways to the corporate sector, it would be very highly irresponsible if the new company legislation does not keep pace with this sordid development, sir. Sir, experience has shown that it is not the mere change of law alone which matters, sir. It is the effective administration of law which matter more. For example, other day, Honorable Minister, in the last Friday, I saw his quote, sir. He had made a statement. 2.5 lakh companies have not filed their financial statements, sir. In the Companies Bill 1956, we had an enactment, the clause was 211, and now it is in the Companies Bill 2011, it is 129, sir. It says the financial statement of all corporates should be given to the Companies Affairs Ministry with audited accounts, regulated audited accounts. So making mere the laws is not important, sir. How effective is administration of law is what matters much, sir. So I am trying to say here, sir, it is but natural to expect a new company legislation to be better than the existing one in all respects. But if this has to happen, let us engage in a constructive and introspective discourse how the new company legislation should address the challenges of a rising India, sir. New company bill has 29 chapters, sir, 15 salient features, and there are 470 clauses, and 470th clause has 7 schedules. So, as compared with the 1956 bill, which had 700 sections, however, in reality, sir, the new company law will have more provisions if one were to take the account of number of rules that are on annual, sir. Rules have to be formulated in at least 350 items listed in the bill by the ministry, sir. It will be not surprising if effectively new law ends up having 1,000 or even more provisions, sir. As far as the standing committee report, Honorable Minister was saying most of the recommendations have been accepted by the ministry, and there are around 10 or more recommendations which have been either not accepted or partially accepted, and 21 new proposals which were not included in the 2009 bill were sent to the standing committee, and they were included in the recommendation and included in the bill, sir. Sir, what I want to say here is, sir, while making the rules should be prescribed by the ministry at a later date, sir. The motive of consolidating the law would be difficult to achieve if so many rules are to be prescribed, sir. It is not yet known when and how these rules will be framed. The ministry will be able to change the company law time and again without getting parliamentary sanction. The result of such huge amount of subordinate legislation give enormous clout to the bureaucrats in the ministry, sir, in anxiety to reduce the length of the act. Many substantive aspects of law like definition of KMP, key managerial personnel and related party, class of companies that may have layers of subsidiaries and number of subsidiaries, duties of debenture trustee, etc. have been left to the prescribed by the rule, sir. My apprehension here will be, sir, if we are not forming the rules. For example, it has to be, we have to take a cue from the ministry, minister should take a cue from the finance ministry that a pre-publication of draft rules so that all stakeholders could give their views. Before formulating the rules, you have to have a pre-publication of a draft so that all the stakeholders can give their opinion and their views, sir. The government will straight away notify the clause 469 of the bill has no provision for pre-consultation. Through you, sir, I urge the government and the minister could take a cue from the approach taken by the government in deliberating GAR proposals in the direct tax code with all the stakeholders so that their concerns are taken on board before finalizing the provision with the substantial amount be given to them, sir, so the consensus is built up. As Honorable Minister was stating while he was placing the bill on the table, sir, he was saying he will be taking the consensus of all the stakeholders with you have a transparent manner, he said, sir, I appreciate, and he has to clarify that having a given more amount of time to the stakeholders, so inputs can be given by the stakeholders, so that there will be no chance of getting it, you are getting a blame out of it, sir. Sir, I would like to say some of the salient features in which the government has made in this 2011 bill, which are appreciated, including the having a e-governance and the concept of CSR being introduced for the first time, sir, and having a woman director and NCLT in view of the 11th May 2010 Supreme Court judgment, and investor protection and SFIO, as you said, sir, serious fraud investigation office is getting a first time the statutory status, which all we welcome that, sir. But I would like to have some suggestions regarding one or two. Sir, in case of transparency, the Honorable Minister was talking about transparency, but I would like to say in the Article 29 of 2011 bill, sir, demat of securities is mandatory for listed and such class of companies as may be discussed, optional for others, he has said, sir. But I would like the Honorable Minister to have the clause mandates that all companies making public offer and other class of prescribed companies shall issue securities in demat form. Since this is a good corporate measure which will eliminate frauds related to loss of securities, the ministry should, in a time-bound manner, make this clause applicable to all companies, sir. So, as we have done in many other cases, you fix a time-bound frame so that all the companies will have a demat share certificate, sir. And when it comes to clause 326, he was saying about the provide for overriding preferential payments to workmen dues and debts due to secured creditors in case of winding up of a company. We appreciate, but the workman's salary and wages which are payable for a period of 2 years, I want to know how you have come to a conclusion of only 2 years and how practical is it? See, because if a company is winding up, how can he pay 2 years wage to the one in early? So how you have come to a conclusion in fixing that 2 years? I want to seek the clarification through you, sir. Then we have, sir, The bill also intends to transfer certain powers to presently being exercised by the company law board to the central government, sir. The transfer of certain powers from quasi-judicial body like the CLB to the executive will also have its unintended consequences. If past experience is anything to go by, there is every likelihood of misuse of this power by the concerned officials by way of resorting to a red tapeism, sir. The bureaucrats will have to have the freedom to use their discretion for giving rise to the corruption, sir. To ensure the proposed discretionary powers are not misused by the Babus, the ministry should provide for safeguards by way of detailed guidelines, sir. Guidelines are very much important so that the discretionary powers should not be misused by the bureaucrats in the ministry, sir. Then I'd like to add upon one more thing, sir. SFIO is welcome move, but seeks to reform the institution of SFIO with the intent to strengthen the investigation mechanism by giving it a statutory status and other prescribed powers, sir. The power of arrest will not only allow them to be taken seriously, but to also help prevent destruction of evidences by the accused, sir. There are times that I am unable to understand. The ministry has said in appointing the SFIO in the clause 211 subsection 2, sir, the serious fraud investigation office shall be headed by a director and consist of such number of experts from the following fields to be appointed by the central government from among us the persons of ability, integrity and experience in banking, corporate affairs, taxation, forensic audit, capital market, IT, law or such other fields as may be prescribed, sir. I am unable to see how he is going to find this type of people, sir, and where is the capacity and how you are overcoming. This is the serious point, sir. Mere makingly one law doesn't make the law active, sir, because it has been seen how you are going to get officers or bureaucrats, how you are making them deputation. When a person comes from a different department as a deputation, he will be there for some time and he will move off, sir. So my concern with that is how effective it will be and how it will be challenging to the ministry to have this, sir. And when it comes to there is one clause 203, sir, which says that the separation of the same is in the case of separation of chairman and CEO or the MD post. Clause 203 says that separation of the same is mandatory unless the article of the company provide otherwise, which gives company an easy escape route, sir. A better governance system requires that statute should provide for separation of powers rather than leaving it to the corporates for doing it voluntarily, sir. Mandatory should be there. It should be through the clause, sir. Otherwise, they will escape it through this escape route, sir. I need a clarification from the Honorable Minister for this section, clause 203, sir. And in clause 149, read with schedule 4 is an attempt to legislate good behavior into law, sir. Some of the clauses in the code are really absurd. For example, one of the clauses relating to the role and functions provides that independent director shall balance conflicting interest of stakeholders, sir. Now a director in a small firm in times of sluggish demand will look at firing an employee to protect the company's interest or look at protecting the employee's interest. The ministry had constituted a committee. I want a reply from the Honorable Minister under the chairmanship of Adi Godrej to formulate policy document on corporate governance, sir. In its report dated 18th September 2012, the committee has observed as follows, sir. Good governance cannot be imposed. It must emerge from a changed social culture taken down to the level of the corporation by capable and committed directors and executives, sir. So I need to know whether that committee report has been reached the ministry and have you accommodated any suggestions given by that committee in the present bill. I need a clarification from the Honorable Minister, sir. The need is to promote such ecosystem in which capable and committed independent directors contribute their best to strengthen the board process, and for their efforts, the independent directors are sufficiently incentivized. In this regard, it is pertinent to note here that in clause 197, subclause 7 of the bill prohibits stock options to independent directors. SEBI guidelines allow ESOPs to the independent directors. Global practices relating to ESOP permit stock options to independent directors, but independent directors are expected to contribute to a shareholder value creation, so any remuneration mechanism that delinks the remuneration from value creation would discourage them from performing the larger role of contributing the shareholder value creation, sir. This is the point should be noted, and something has to be done for this also, sir. And when it comes to the CSR, is the current understanding of CSR in India relevant and adequate is the big question right now, sir. What are the different delivery systems for CSR programs in India, sir? And basically we should try to find out what are the difference between CSR, business responsibility, and responsible business conduct, sir. How can a supporting policy environment for its operation to be developed in the country? Because this is the first time, Honorable Minister was saying, the first time the CSR being introduced in our country. So here we should look into, there is a debate on CSR in India among everywhere, sir. Government, civil society, business community seems to be raising more questions than answering them, sir. Various quarters have approached the issue differently, leading to this confusion. There is such a variety in this discussion that many in the audience, including myself, sir, are confused. What is CSR? How it is going to be delivered? How you are going to integrate it? How it has been enabled? How it can be mandated? How government is going to be partnered in it? And it is a big question, sir. There are so many questions are raised, but nobody is having an answer. How practical it will be? If you are having a self-regulation on the corporate sector, and you know how well they can, as Honorable Minister was saying, they had a total pressure on them and the stakeholders were complaining about the CSR. We would like to know how it can be delivered and how it can be integrated, sir. So this subject of CSR has a long evolutionary history in India, sir. The evidence is witnessed in the words of great thinkers and visionary leaders in the country, right from the Kautilya in the 4th century to Jamshedji Tata in modern India, Mahatma Gandhiji, and to now we have N.R. Narayan Murthy been in having a social responsibility, sir. But however, said and done, but it was unknown recently, but it is today one of the most important topics for discussion for everybody. Business undoubtedly has a responsibility for wealth creation, sir, but also has responsibilities for social problems created by business or by other causes beyond its economic and legal responsibilities. Corporate activities should be such as to cause less harm and more beneficial outcomes for society and people. When society gives license to business to operate, it is only fitting that business serves society too. Apart from creating wealth is the criteria, sir. And some of the definition regarding CSR have been, I can quote one, I'll conclude within 2 minutes, sir. Sir, because as the Honorable Minister said, it is the first time they are introducing CSR, so I think deliberation and lot of discussion on CSR should be given trust, sir. I urge upon through you, please give me another 2 minutes, I'll conclude.
Yes.
CSR has been defined in a number of ways by leading global institutions, sir. One of the most comprehensive definitions was coined in 1998 by the World Business Council for Sustainable Development, sir. An alliance of 200 leading global business committed to promoting the role of business on sustainable development issue. According to this definition, sir, CSR is the continuing commitment by business to behave ethically and contribute to economic development while improving the quality of life of the workforce and their families, as well as of the local community and society at large. In 2011, European Union adopted a much simpler yet more comprehensive definition of CSR as the responsibility of the enterprises for the impacts on society. This replaced its earlier 2001 definition of CSR, a concept whereby companies integrate social and environmental concerns in their business operations and in their interaction with their stakeholders on a voluntary basis. The new definition marks a significant progress towards the encompassing all dimensions of sustainable development into CSR policies and practices as compared to the earlier one with an emphasis on impact, sir. A noteworthy difference is the addition of economic elements, sir. It hereby touches all the three elements: social, environmental, and economic of sustainable development. Sir, with these few words, I will conclude my speech, and I will seek the Honorable Minister through you to clarify some of the doubts which have been raised in this. Thank you very much.
Shri Sanjay Nehru.